The Simply Successful program offers stress management tools for the lifespan, so small children, adolescents, or adults can be simply successful.
Hello, I'm Deb Timmerman.
And I'm Beth Tuttle. Welcome to the Simply Successful program. We teach stress management skills that build resilient kids, successful families, and thriving communities.
Today, our guest is attorney Rose Connen. Welcome, Rose.
Thanks.
Rose's specialty is estate planning. So when we think of estate planning, maybe you think about finances, but today we're going to actually talk about another asset in your estate, and that's your children and what happens to them if something happens to you. So Rose, you do a lot of work with families to put legal pieces and documents in place to make sure that there is a caregiver for their kids should something happen. How do you go about that process, and why is it important?
Right. So a lot of people, when they hear the term estate planning, they think that that means they have to have assets to plan. And so they say, I don't have assets, I don't need a plan. And that's not true, because if they have minor children, they need to provide for those kids. Sometimes it is planning for their financial future, but more importantly, it's who's going to step in and take care of those kids, who's going to step into the role of parent, who's going to step into the role to manage what assets there are. And so that's where we get a will in place, nominate a guardian and conservator, and maybe some additional documents, a power of attorney. So if there's an emergency situation, who immediately can step in and care for those kids.
So if I'm understanding things correctly, a guardianship doesn't happen overnight. If something happens to you, say you get in an accident on the way to work today, and you're single and you have one child and you're that child's sole guardian and custodial parent, your family can't just take over and do things for that child unless you have certain pieces in place. Is that correct?
Correct. So if there's another non-custodial parent out there, they could come in and assert rights if their rights haven't been terminated, and that might not be the best place, especially if the child hasn't had a relationship with them. If there's family available, maybe authorities will let that family take the child. But if not, they could end up with protective services until they find somewhere for that child to be, or there's a guardianship put in place. So we can do what's called a delegation of parental rights or a power of attorney that gives someone temporarily the authority to make decisions on behalf of the child, medical decisions, school decisions, and that would give them priority too in seeking guardianship if there's not a will in place. That we know this is who the parent wants that child to be with. We've got that document, and that can be used as evidence in a guardianship proceeding.
Why are we talking about this on a stress show? Things happen, and when children lose a parent or a significant caregiver in their lives, their world is already turned upside down. To not be able to make decisions for things like maybe they need immediate counseling or they need to go to the doctor, that's very stressful for whomever is taking care of that child, but it's even more impactful on that child. And we do a lot of work with adverse childhood experiences and trying to eliminate those so a child's not scarred for life and having health issues because of these significant traumatic events that happen. And the death of a parent is very traumatic. Could you give us an example of a time in your practice when you had to help a family who didn't have a plan in place?
Yeah, so we've had situations where a custodial parent has passed away, and the non-custodial parent that didn't have a relationship has come in and asserted their rights, and the family that has been the primary caregiver, it's a court battle. It becomes a court battle. You've got to then go in and show what's in the child's best interest. Priority is always going to be given to a parent. So we've got to overcome that hurdle and show why that parent might not be the best guardian. And that takes an emotional toll not only on the family, but on that child.
And it doesn't happen overnight either, does it?
No. It's a court battle. It's
What's a
long
typical
and drawn out.
timeline for that?
If it goes all the way to trial, it could take a year. It could take a year. And
so meanwhile, where's this child? What's happening? Are they in foster care?
They typically not in foster care if there's someone to provide for them, but it might be with a family member that's not ideal. It might be with a family member that the parent that passed away didn't think was appropriate to have custody. And meanwhile, you've got a child who's been uprooted, and maybe now they're in a new school district, they're in a new home. They're with family that they don't know. And so it's dealing with that aspect as well.
Yeah, so imagine the trauma for the child after they spend a year possibly with a father that they hardly ever seen, uprooted to all these schools, the process of going through the court to maybe get with a grandparent, and now they're again uprooted and starting all over again.
I don't think any parent thinks about their mortality and wants to plan for it, but it is really important for your child's sake that you do some planning. You work with a lot of special needs children and families as well. How does that differ from a regular situation?
So any minor children, anyone under the age of 18, we always recommend they have a guardian conservator in place. And if they have a child with a disability that may need assistance once they reach adulthood, we have to look at planning beyond the age of minority into adulthood. Do we need to name a guardian and conservator if they're not able to manage their funds on their own or live on their own? This will help them have someone to assist them. It helps protect them. They become more vulnerable to other people coming in wanting to help, but in reality maybe trying to get at some of their money. So having a guardian in place, we do it in a similar way in the estate plan, where we name someone to step in and be guardian for that disabled child. It could be a matter of going into probate court and getting guardianship. But that, again, is that parent plans for that. And they can name a standby guardian. So if something happens to them, we've already got someone ready to step in. It can be naming it in their will. So there's lots of ways to plan for that as well.
And for a special needs child, having a relationship all along with that person that could be their guardian or conservator is probably really important.
Right. Yeah, and if there's not a family member or someone to step into that role, there are public guardians. So the court could appoint a public guardian for that child, someone that doesn't know them, someone that has a caseload and is handling multiple people's finances and care, and might only see them once every 3 to 6 months.
Well, I have some experience with that. So my background is long-term care nursing, and we had someone come to our nursing home that had a public guardian, and you're always obligated to call and keep them updated about things that are happening. And I can't say that they were very responsive. Now, I'm sure that doesn't happen in every case, but it always made me think about who was there for that gentleman and who was going to watch out for him.
Right.
So we kind of took that role on with our nursing home family. They would buy him things and do other really good things from the bottom of their heart because they really cared about this individual. So if you could leave parents with one tidbit, one really good nugget, what would that be?
I would say don't delay in getting a will in place. At a minimum, everyone should have a will if you have minor kids. Don't delay, don't put it off because you don't have the right person in mind. You'll never have the right person. Nobody can step in and be a parent like a parent can. But you need to get somebody named. And there's lots of different factors that we go through and can kind of counsel a parent on who might that person be, but get something in place.
So you do like an intake process to figure out where parents are at and maybe help them do a discovery about who might make a good conservator or guardian?
Yes. So there's different things we would look at. We would look at, who's going to have similar, sometimes religious beliefs are a concern. Who's a guardian that might have similar religious beliefs, or education philosophy, or discipline techniques, or who's financially able to take on another child. Longevity is an issue. We want someone who, if you're coming in as a guardian, you're there for the long haul. Who's going to be able to be there both from a physical standpoint to take on that role and from the mental standpoint. So there's lots of different things that we kind of walk through to figure out who that right person might be.
So it sounds like this doesn't have to be a horrendous process. It can be something that's, although not pleasant to think about, but it can be something that will help you feel secure and maybe have a comfort level knowing that your child will be cared for should something happen to you.
Right. Where
do our listeners find you, Rose, if they need help?
They can find me on the website at Coonen-law.com.
Could you spell that website, please?
Yes. It's www.coonen-law.com.
And you can find Rose on Facebook?
Yes. Coonen Law is on Facebook.
Okay. If they want to reach out to you by phone?
They can reach me by phone at the office. The number is 616-951-1531.
You can find stress management tools on the simplysuccessfulprogram.com website as well. Again, that's simplysuccessfulprogram.com.
Thanks for listening.